are current fellows of the organization. If you're not, and you are a labor and employment lawyer and have been for at least 20 years, we encourage you to find out more about the organization and talk to the person next to you about becoming a fellow. We'd love to have you join us. I'm very happy to see so many of you here. We've got a great program planned for you, Mark Risk and Judge Michelle Childs. And so I'm going to let them take it away. Thank you.
Thanks, Lori. Good afternoon. Thank you all for coming, and thanks to Judge Childs. I would be hard-pressed to think of an Article III judge in the country that more of us in this room have met or otherwise think of as a colleague than Judge Michelle Childs. She has practiced law in the spaces that we work in as a working labor and employment lawyer in the private sector and as a state government official in the workplace spaces. She's been the secretary of our ABA Labor and Employment section. She's attended the meetings of some of our committees where many of us have met her. She's been active in the labor and employment bar and bar associations where some of us have also met her, including as chair of the labor and employment section of the South Carolina Bar. And I thought I was prepared. And Brad Hoffman said to me about an hour ago, well, she was a government fellow to our section 24 years ago. That's how we first met, and I had no idea about that. So you seem to be everywhere. I first met Judge Childs here through the ABA, but then elsewhere up in New York when you were a district judge sitting in South Carolina after you served as a state court trial judge there. So it was exciting for me to learn that she had been nominated by President Biden to the U.S. Court of Appeals for the D.C. Circuit. And then I was watching television one night, and I learned she was among those under serious consideration for the vacancy on the U.S. Supreme Court that ultimately resulted in the nomination and confirmation of Justice Contentious Brown Jackson. So you've had a bunch of interesting jobs, and we have 90 minutes to talk about them and about the ways that they knit together to make what is extremely interesting and varied career. And of course, we'll talk about the DC Circuit as well. I have questions, but we'll leave time for the attendees to ask you some questions directly later in the program. You were a motivated student and a high achiever early on. You were valedictorian of your high school class in South Carolina. You went to the University of South Florida on a full scholarship. You came back home to go to law school at the University of South Carolina, also on a full scholarship. What pointed you in the direction of a career in law, and when did that begin to happen to you?
Thank you. Well, let me say thank you to Lori, thank you to all of you fellows, and I feel like I really am at home, as he's indicated by the resume. I've practiced labor and employment law for quite some time, and then thank you, Mark, because he's done an outstanding job, as you'll see, in preparing for today's hearing. Well,
today's hearing?
I was wondering if he would catch that.
I'm not prepared for that.
Except he's getting to ask the questions. Good catch. Listening lawyer, I like that. So one other anecdote to this, because I do think it is a through line to perhaps an influence on my career. I'm originally from Detroit, Michigan, and my mother worked for Bell South. She started out as an operator and then worked her way up to high-level management in human resources. So you never know sometimes how your parents are influencing you. So my undergraduate degree from University of South Florida is in management. And then I did the dual degree at the University of South Carolina, where I have a management and personnel relationship master's as well. So, and then practice labor and employment law. But back to your question about high school, it is so important that lawyers volunteer. I'm a first generation college student on both sides of the family. And it was a mock trial proceeding at the high school that I got involved with that gave me my entree into law. I thought I wanted to be a psychologist. Now, of course, we use that as skills, within our profession. But it was that opportunity to take inside of an argument, study up on it, do the research and writing, and then articulate your thoughts in, that convening. And that's really what got me on my way to being very interested in law.
There's a story about your scholarship to the University of South Florida that seems to involve an athletic recruiter. Can you share that with us?
Well, as a first-generation college student, I spent a lot of time in the guidance office, and the guidance counselor was very good. She was helping me get waiver applications, directing me to where to go to school and things of that nature. So one day, this tall gentleman walks into the guidance office, and he says he was looking for one of our star basketball players. And I said, why is it that we keep getting recruiters on campus for athletics, not academics? And I said, what school are you with? And he said, University of South Florida. I said, how about you introduce me to your school, and then I'll introduce you to this athlete. So we talked for a while. And he said, wow, I'll give you my card. And I did follow up with him. And so I applied for University of South Florida, got a full scholarship, but even better, I got a job tutoring the basketball team.
As I said, you're really one of our own. You've worked in different sides of the labor and employment law practice. But for your first 7 years out of law school, you practiced in a private law firm in South Carolina that was then called Nex & Pruitt. I think there's been a merger subsequently. Yes. Primarily, I think, in the representation of management. But tell us about the work you did there.
Yes, and so as any law student will have, you'll go to different firms over the summer. So I did go to other big firms. And one thing that was interested in is one of the firms, they wanted you to do an 18-month rotation to various practice areas, and then you would land. Well, I knew I had an interest in labor and employment law, and this particular firm let me go directly to the labor and employment law team. So during that practice, they gave me a lot of great experience because there's so many fields in here, as you all know. I got to do advice counsel. I did litigation representing management with respect to discrimination and harassment. I did a lot of grievance board work with local governments, wage and hour work. Back then there was affirmative action plans, so I handled some of those as well. So I got a taste of all of the various components of the labor and employment law.
And you were there 7 years, I think, and you did what many people in this room have probably done, is hustle and become a partner. By the way, the first black woman partner at a major firm in South Carolina. No, but hold your applause. As far as I can see, very soon thereafter you left the firm to accept a gubernatorial appointment, very soon, a gubernatorial appointment as Assistant Commissioner of Labor in South Carolina. How did that come about, and what were you thinking at that time about where you were headed and what you wanted to do?
Well, I was only partner for 6 months, but I still get to say I was partner. But actually, I got a cold call from the governor's office asking me to run our division of labor. And so I originally told him no, dare me do that, because I felt like I had worked so hard to become partner. I rang the bell, and I was wanting to see what that experience would be like. Well, they didn't stop. They called me again. I told them no again, believe it or not. And so then they came back a third time, and I said, I'm missing something here. So I started talking to my friends who had gone into government, who had gone into in-house counsel, people who had left private to go to public service, and then realized he had asked me to fill the unexpired 2-year term of the former Deputy Director of Labor. And then they said, think about it this way. You would be the CEO of labor for the state of South Carolina. All of the new business, all the companies coming through there route through you. And then the head director, she was a private firm person as well, had been partnered at her firm, and she left government. And we became great friends, but what I liked about her is that she wanted me to be out there. She wanted me to be speaking, dealing with companies, and doing things of that nature, and being meaningful when we say, we're with the government and we're here to help you. And so at age 35, I ran the division, which had 6 programs under me, and I had 100 people under me. And those programs included labor management, conciliation, migrant labor, elevators and amusement rides, believe it or not, and then wage and hour, and then wages and child labor as well. OSHA, and then OSHA voluntary programs as well. And so that gave me just a full template of all the labor issues in the state of South Carolina. So when that 2 years about to end, then I had the opportunity to go back to my firm as partner, but then other firms had called me about coming in as partner or going to actually do in-house counsel work as well. So I had a wonderful time during that time, just even doing things like when I happened to coincide when I was president of the South Carolina Bar Labor and Employment Law, I put together a wonderful CLE with management and government persons like the NLRB and the EEOC to bring them together so that we would create a situation where we didn't want it to all be about compliance or regulation, but that you would actually know these people in government, and so that you would better represent your clients in that regard, because we would know and have those direct communications. So I'm not getting the call for OSHA and then all of a sudden have to be involved in a citation against your company, that we were forming great relationships.
But the 2 years ended, and you accepted another gubernatorial appointment. So tell us about that.
Well, the governor called again and said, I want to appoint you to be a workers' comp commissioner. And he gave me 24 hours to decide and said, you can't tell anybody. Let me know tomorrow. And so I only told my mother and my then fiance, now husband of almost 23 years. And so said yes. And it really was a good opportunity because it was quasi-judicial. So I think that's what kind of started me on my track to becoming a judge.
Was that an aspect you thought about at the time, or that's what it's quasi-judicial as you see it in hindsight?
Yes, I did think about it as an aspect at the time, because at some point I thought maybe I'd consider becoming a judge, just because some of the partners in my firm had kind of put that bug in my ear and gave me many opportunities in the bar to get to meet people and things like that. And so I said, oh, this is a great opportunity to do something like that then.
And after 7 years in the private bar, and now, I don't know, several years in 2 significant government positions, do you recall whether your perspective about labor and employment issues was evolving or changing in any way?
I would say so, because when you're at the Division of Labor, I had the opportunity to not only serve as the programmatic person, over those particular managers in those 6 fields, but also was anything that was happening at the division would get appealed to me. So I got to serve in an appellate capacity and really understood what compliance and regulation meant at that point. Then when you come over to workers' comp, I'm in charge of workplace injuries to the extent that those cases are brought to us. So compensability, you're looking at an injured worker. Also, whether or not they're going to get their medical benefits, for how long, are they going to get partial disability or full disability? And so you look more from the component from the employee side, where they're right literally in front of you with respect to all of those issues. So I do think that it helped me discern more about credibility, workplace issues with respect to managers, and how employees deal with each other, both at labor and as workers' comp.
In 2006, I believe, you were, and I'm told, elected by the legislature, and you'll explain to us how that works, to serve as a judge in Richland County, which is your home county of Columbia, yes, South Carolina. How did that come about, and what do you recall about the changes in your professional life as you moved to the bench?
Well, I got another call, so answer your phone.
But not here.
Not here. Actually, interestingly, a legislator called me because in workers' comp we deal with the commission side, as I indicated, quasi-judicial, but then there's also the business side of the employees running the agency, et cetera. And that particular legislator had a constituent who was applying for a job in our agency and then said that they felt like the way the position was advertised wasn't fair. And I told her, I said, okay, as an employment lawyer, I want to make sure that we're doing things correctly. I don't know your particular employee, and I will not represent that I'm going to assist the person. I just want to make sure that the application process is fair. And it did so happen at the time that we had advertised that you needed a college degree, but for some reason we were interviewing people who did not have a college degree. So I went to management and I said, we could get sued if you all don't follow, what you have put out is your qualifications. So let's just stop it there. And so she just respected that I stood up and just made sure things were correct. That's all she expected. And then later on, a position became available in the General Assembly, and I got a call back to say, you might want to consider running for judge. Now, South Carolina and Virginia are the only two states that I'm aware of that have to run through the General Assembly as opposed to a public election. And then through that process, you go through judicial merit selection screening where you fill out the application, you have a screening hearing, but then you also do other things that the bar has an interview process, and then you have a citizens interview process. At that time, we also had to take a test on about 6 subjects: civil procedure, criminal procedure, evidence, professional responsibility, a year's worth of the Supreme Court opinions, and we had 1 hour for the test. And so then they are only going to let 3 people out of screening. There were 6 in our race, and so I was one of the 3 that came out. It's only after you come out of screening that you could actually approach legislators to ask for their vote. Before then, you're just trying to get around and see who knows whom and those types of things. And then within 2 weeks of the race, I had enough of a count that I ended up winning by acclamation. Everybody jumped out the race.
People get to the bench in different ways. Do you think your years as a working lawyer and then as a state government official shaped the way you approached the craft of judging when you got to the bench?
Yes, and I do believe in bar leadership and being infiltrated in your bar, because beginning with the process of a confirmation actually for the workers' comp through the Senate, the governor appoints, but then you have Senate confirmation, and then having to go through the General Assembly and figuring out who among your peers knows people that can help influence the vote. All of that matters, because in all the process that came later, you need people to speak on your behalf. And I've always told people, you can be the smartest person, the corner office view, but when there's an opportunity, how many people can call your name off the tip of their tongue, literally, because that is what has happened in my career, where you're doing the hard work, but you're also giving back, because this is a profession of honor, it's a profession of privilege, and then that's the way to meet people, and then that helps you rise, but it's also just an honor to give back and learn from others in that respect, and then create a broad circle coming from within the profession.
You served on the state court bench for 3 years, during which you ran a business court pilot program and also served as chief judge of general sessions in the state criminal court. Can you tell us about your work in the state court?
Certainly. So starting with the pilot program, our Chief Justice at the time believed that she wanted the courts to be business friendly, that, as you can imagine, the state courts are very backlogged. And so as part of just trying to help anybody who was going to be introduced into our state system through the industry, we designated those cases essentially like some places do as complex litigation. But we only had 3 pilot programs where 3 judges in 3 different counties took all the business cases. And so that meant that when I had the case, it's almost like being in federal court where I'm the judge assigned from beginning to end. So you don't risk that you jump around with different judges and you get different decisions, different ways at different points of the case. Then all of our orders would also be online too, so that we could create a body of work so people would know how we were going to rule in that regard with respect to the pilot program. With respect to general sessions, which is basically criminal court, our chief judge appointed me there. And to me, wherever you are, you should try to make it better. And the way I tried to do that was efficiency in the docket. For example, I recall a trial specifically where a gentleman was charged with armed robbery, which carries a sentence of 10 to 30 years, petty larceny, which is 0 to 30 days, or grand larceny, 0 to 5 years. This gentleman had been in our county jail for 18 months before his case came up. When he went to trial, he got convicted of petty larceny. So then I called the solicitor who, in our state, brings the cases, and I said, not on my watch. So I also called the jail warden, and I said, give me every single case that has anybody 18 months or more. Well, I found out that there were people in there 4 and 5 years whose cases had not come up. So I went to the solicitor, and I said, while I'm here, I control the docket. And so we started doing status conferences, and I would let the lawyers pick, when they would have it, because then you would have a murder case up on Monday morning, but then they forgot to get the DNA, or did they? Things of that nature, and I just wasn't gonna have gamesmanship. I wanted prepared lawyers who knew exactly when their trial date was, because these are big stakes, on any of these types of cases. And so when I started, the jail was 200 over capacity, and when I finished my term in that 6 months, it was 200 under capacity. Because what I did was also made sure that I pulled all cases and made public defenders and private bar people work with the solicitor's office, brought them into roll call meetings and said, everybody work together. What cases can we agree on that should be time served, based on people being in jail? What cases can we agree on should be probation? And then I'll assign several agents and we'll, beat that up. And then the third category was a negotiated sentence. The judge has the opportunity to not approve it, but it still made them work together. And it just took the bubble out, both on the solicitor side and the, other side. Another thing I did was private bar people, lawyers would be sitting there all day waiting on one plea. And I said, that's a lawyer's time is their stock and trade, as we would say. And I said, we're not gonna do that. So on Mondays and Thursdays from 12 to 5, I will be here for the private bar. Federal public or public defenders go to jail, so I don't get letters from them saying that you're not coming to see your clients. And then everybody else just knew that that's the time that you would get your business done, and then we would have other opportunities. And we would just run vans from the jail because they knew that we were going to, during that week, if I had to do 150 pleas, that's what I would do.
We've taken you through school and through most of the first 2 decades of your legal career. But let me stop and ask you about 2 of the things that bedevil me, and I'm sure a few other folks here, imposter syndrome and confidence. At that point in your career, or now, how do you deal with those 2 demons? Where does confidence come from?
Well, you have to have good mentors in your life, and I think that's outside of the profession as well as within the profession. So I've always sought out, even in bar leadership positions or other places, just people to assist me along the way that I could talk to. But it's not just in mentoring you. I had a lot of sponsors, and to me that's the next level, that they are willing to stand for you, willing to offer you those opportunities, and quite frankly, he mentioned that I was the first black female partner in my firm, a majority firm in South Carolina. Well, there were 3 other black females that over a period of 5 years, I got them to be the first black partner in their firms as well. And so you just take the time and just go through the politics, go through the moments where people might, almost want to cry about an issue that's happening at work. I mean, things are going to happen, and how do you deal with that? But you also just work hard, and you just let merit be the thing that carries you forward, and just work harder and get on as many assignments and do more work than perhaps others are doing sometime, but you just have to practice it. There's no shortcuts.
President Obama nominated you in 2009 to the U.S. District Court in South Carolina, and you were confirmed in 2010. What new challenges did your slide over to the federal bench present for you?
Well, one thing about state court is because we ride the circuit, you could be up on Monday morning and you have the motion to dismiss in a case, but the next judge a few weeks later might have the motion for summary judgment.
Right.
And then there's just such a distinction in all the various practice orders. Am I up for murder on Monday? Am I up for a construction litigation or a medical malpractice? But one thing about federal court that was wonderful is that you have that case beginning to end. So you have the opportunity to learn the lawyers, you have the opportunity to learn the case, you have the opportunity to manage things. And then we did a lot more research and writing on our own. In state courts, you might have lawyers giving you the proposed orders, you can tweak them, some of them you write on your own, but we're doing all of that work in federal court. And I like the opportunity to just manage, the docket, be more efficient about it, decide what needs a hearing, decide what can just be dealt with on the papers, and so, have the opportunity to run the docket. And just the subject matter, breadth, fabulous lawyers, arguing, articulating in front of you, and me learning from you all.
And moving to the bench, and then not long thereafter to the federal bench. Were there special challenges for you, in your view, as a woman and as a person of color?
I would say that ever so often, you would just have maybe the more seasoned lawyer coming in and, and they might say, yes, sir. And I'd say, hello, there's a woman up here. You would just get used to, some of those things. Or they would just perhaps try to guide you in such a way as if they were the smartest person in the room, or they knew the answer, or what have you. And so you would, and I've even had, sometimes people be flippant where they'd say, so why'd you call me for a hearing? What do you want to know? You're lucky you have a hearing in the first place, because we don't have to grant them, and there's probably something I want to know, because that's why I set the hearing. So shall we carry on? Those types of things. So every once in a while there would be just kind of that tinge of something, but just handle it courteously, diplomatically, and then people start gaining their trust and confidence in me when they just see the work, the efficiency, and the writings.
Judge Mark Bannett, now retired from the Northern District of Iowa, used to speak to us often in our section, and he thought a lot about jury trials and jurors and cared about them a lot. He redesigned his courtroom so that the witness box was in the center, and he put the jury instructions on PowerPoint slides and presented them to the jurors that way. Do you have opinions about federal trials and how they should be done, or how they might be made better? Did you do anything unusual in the running of trials in your courtroom?
Well, one thing that I have done, and I learned it from another judge, is that whenever I'm having a trial, afterwards I'd go into the jury room and just thank the jurors for their service, not trying to talk about the case or anything, because I don't want something to come up after that. But they would just fill out this one question and say, is there anything that could have been done better? And so I started anecdotally taking down that information and found out that there was kind of a consistent theme, and I'll share some of those with you. One is the jurors would always say, don't be so repetitive. We get it. We're smart, And then, of course, on the federal system, if they've had to apply for voting, then those tend to be jurors a little more experienced. They would also say, don't be condescending when you are questioning a witness, because they identify with that person as an employer or as anything else. So you can get what you need through the questioning, but you don't have to make it personal, with them. Another thing I noticed is that with respect to jury charges, they need to be as clear and simple as possible. And then you need to help them through the legalese by connecting the case factually to some of the legalese in the charge. One thing that I've done that I think is helpful is once you all have done your case, and then afterwards I'd spend 30, 40 minutes reading the jury charges. It's like watching paint dry,
Right.
And so I asked the lawyers,
right.
Do you mind if we get the jury charge conference out the way, we all agree on the charges, so you don't say, I think the judge will charge you that such and such. Mm-hmm. And that has been a lot better, because I feel the lawyers should have the last word and have the passion to the jury and do all the connecting. So I think that has helped a lot, just with kind of closing the case in that regard. Other things are things like expert witnesses. I have had an expert witness in a case where they literally got paid about $1 million. It was a products liability case. And you would think that, punch that home, run that home, and did that matter? Didn't matter to the jurors because it was how well that expert was prepped. They knew their information, they came across very well, and the jurors were more concerned about substance. And the comment was, you lawyers are getting paid too, so I don't care. And so just think about, again, these are lay people, professional people, but they think about these things, in a more common sense manner. Another thing would be on how you articulate your damages. When, on the plaintiff side in this particular case, just kind of put out some numbers there. Well, they couldn't rationalize why that number. You have to equate it to something, whether it's suffering or whether it's the wages or, you just got to do the math. You got to show your work on how you're going to get that number, so that's helpful. One thing that when you mentioned Judge Bennett, I started putting the biased jury charge up front, like when I give my initial instructions to the jurors, and then also later, just so that we make sure the decision is not made on the grounds of any prejudice, sympathy, bias, things of that nature, and those types of things are helpful as well.
There's a lot of conversation in the profession about the vanishing civil jury trial. On the other hand, here in our college, we have quite a number of arbitrators. And in our field, of course, many cases are presented to arbitrators with the full endorsement of the U.S. Supreme Court. And the proponents say this helps working people by making it cheaper and faster for them to get their day in court, even if it's not a jury trial. Do you have views about jury trials? Whether the jury gets it right? Do you care about their survival?
I will say in all of the trials I've done, maybe except one, and it was a sexual assault case by the mother's boyfriend, that I just kind of questioned, because it ended up being a defense verdict. But then when I talked to the prosecutor, she said those are harder cases because you got the child testifying, vis-a-vis an adult. But other than that, I really felt like the juries have listened and they've gotten it right, because if there's great lawyering, they have time to prepare, then they're okay. Now, when I first started, in my first 18 months, I tried 20 cases, and only one was a bench trial and only one was a criminal trial. But then after that, I think people get to know you, they start reading your decisions, they kind of have an idea, and so I think there's some of that going on too about, which cases to settle, which cases to bring. I also had a practice where we have some very well-seasoned magistrate judges. And so in our jurisdiction, they only get to do Social Security, pro se cases, employment and labor law cases. And so they wanted to, have a broader practice, if you will. So I would always offer the magistrate judge's service at no cost before a trial, just to see if there was any opportunity for resolution, because sometimes it just takes the robe coming into the room for you to relay the same thing through the magistrate that you've already told your client. And so sometimes that helps as well. But I do believe that federal practice particularly probably hurts the jury trial just because of the dispositive motion practice. Not to say that you shouldn't prevail, but I do think that it's a lot easier to not even step into court, and our practice is that you could have your case dismissed.
In 2014, sitting as a district judge, you had a case called Bradax versus Haley, which was a challenge to South Carolina's refusal to recognize the marriage of two women that had been lawfully made in Washington, D.C. Can you tell us about the Bradax case?
Yes, actually my case was dealt with on full faith and credit clause. And at the time, as he indicated, Obergefell was not even there. So I had ruled first before the Fourth Circuit got some other cases coming up the pipeline. And then a colleague of mine had one about the person actually applied for marriage. And so, of course, during that time, this is considered a high-profile case, very heightened. I would be somewhere and somebody might say, I can't believe you're going to let gays marry gays, or, things like that. And you just understand your role. Then they did so much research on me to try to figure out how I was going to rule. because I was a defense lawyer, I'm Catholic, and so they were figuring all that out. And so finally, they're going through the clerk's files, just combing for information, and guess what the headline said? Same-sex judge is a hard worker.
Well, you ruled that South Carolina lacked a compelling state interest to justify its marriage laws. South Carolina had argued that its state interest was its right to define marriage its own way. And that South Carolina argued that it had a right to protect the institution of marriage as it understood it and to make its own decision about the optimal child-rearing environment. I gather that there was a standing issue in that case. South Carolina argued these plaintiffs lacked standing, and I don't know, do you recall or all the ways that that couple was injured by South Carolina's refusal to recognize the marriage?
Well, looking back to Loving versus Virginia, it had already been established that marriage is a fundamental right, and then you look to the strict scrutiny standard, and quite frankly, the state did not bring forward any compelling interests in that regard.
The plaintiff was an Air Force veteran, and because of South Carolina's refusal to recognize the marriage, they were denied certain veterans benefits as a couple. They couldn't file joint state tax returns. They couldn't share health insurance coverage, make medical decisions for one another. The opinion goes on and on about all the injury that they had. In 2020, on the district court, you issued a decision in an election case that I guess we might also call a COVID case that ultimately found its way to the U.S. Supreme Court. Can you tell us about Middleton versus Andino?
Yes, so this case started in 2 rounds. First we had the June primary and then of course the November election. And in South Carolina, we required a signature if you were going to have an absentee ballot. And this was in the height of COVID where people were not visiting their families, they were not letting anybody come to the door, groceries were being ordered to the door. And so I felt that requiring that signature was a burden to
This
your
is a
right
third-party signature by a witness to the ballot, in addition to the voter.
In addition to you signing your own absentee ballot. And you would already be able to, through the Election Commission, verify the signature of the absentee voter. But as you indicated, this is an additional signature as to the absentee voter. And so I felt like it was burdening at that time just because we didn't know a lot about COVID. This is right in the height of all of that. The other thing is that the election commissioner, that people don't realize, signed an affidavit basically saying that we don't really check those out. We don't have a way to verify the signature of the person verifying the absentee voter. And then if that's the case, then an 11-year-old can sign, a felon can sign who can't vote, somebody mentally incapacitated can sign who can't vote. And so that was the portion of my reasoning. Then we fast forward to the election, and so I had everybody basically under that rubric that we won't need this extra signature. And even though it was filed somewhat close to the election, as these things do, and that was an unappealed decision, as they do, then you had the Purcell doctrine that you're not supposed to really change election rules on the eve of election. But it's not really been defined, you know, what eve of election is. Mm-hmm. Is that 48 hours? Is that a week? Is that 3 weeks? Because all of these challenges are brought so close to the election. So Fourth Circuit affirmed me, and then the Supreme Court, in a shadow docket, I believe, went against me.
Well, it was, yes, the only opinion was a concurring opinion by Justice Kavanaugh, who said that health matters, I think, should be regulated by the states, and that there was states should regulate elections and not change the rules too close to elections. So I gather that the case became moot at some point, and the Fourth Circuit didn't get to have the last word because the election had been held. Well, President Biden nominated you to the DC Circuit in December of 2021. And if I'm right, it was while that nomination was pending that it was widely reported that you were on a short list, if there is such a thing, to the U.S. Supreme Court for the position that is now held by Justice Contentious Brown Jackson. That, well, exciting for you. That was exciting for many of us because we were able to say to our friends and family, hey, I know her, I've met her in the ABA, so thank you for that. But you're a very vetted person, I think.
I was going to say, it's funny you should say that, just that part, because I would be at conferences with other judges, and then all of a sudden they want to take a picture with me. And I said, you've been my friend forever. Why do you want to take a picture from me? Because my kids don't believe I know you.
Without telling us more than you should, of course, maybe there's someone in the room who would like to be a federal appellate judge or federal district judge or a member of the U.S. Supreme Court. What is vetting? You've been vetted, I suppose, in different ways 3 times. Tell us about vetting.
Well, in this particular process, and as you all can see from some of the confirmation hearings, I literally, on a Friday, before my hearing was to happen on Tuesday for the D.C. Circuit, got a code call from the White House saying, your hearing is not going forward. And I said, excuse me, this is like telling me the bar exam is being moved. Right. I know what I know right now, you know, that kind of thing.
Right.
And so they said, well, your name is circling, you know, because the Wednesday before, Justice Breyer, you know, decided he was going to step down. And so I got pulled. And we had been ready, you know, to go forward, you know, doing all of the mock hearings and, you know, things of that nature. So in terms of what's involved, there's a Senate judicial questionnaire that you can find online. So if anybody's interested, just go start trying to fill it out. It asks you for your most significant cases, because you'll know where your gaps are. You know, your most significant cases, what your trial experience is, all the types of matters you've handled, who you've been against, because of course they want to call those people and see what your temperament and things like that are. There's an extensive FBI background check all the way back to age 18, and so they'll knock on your neighbor's doors and, you know, freak them out that they think something's going on with you. There are several interview processes along the way, you know, with Office of Legal Policy, the White House Counsel's Office, and all of that. And then just constantly people, of course, putting things in the paper, like they were saying I was a big union buster kind of thing and I didn't do any union work. So you'll just have all these attacks, you know, just kind of coming out on you, so just be ready for that. A big combing of your record of all your cases or anything that you've worked on, you know, just trying to find an edge, you know, just with respect to anything. And so that's when your big friends and, you know, associates that you would know during a bar, a lot of people would just kind of speak out for you in that regard. And then I eventually did interview with VP Harris, and then I made my way to interview with the president as well.
Of the United States?
Of the United States.
You were confirmed to the D.C. Circuit position in 2022. Let me ask you about the transitions in your professional life and your life, really, from a trial judge sitting in South Carolina to an appellate judge who hears arguments in Washington, D.C. How does that all work?
Well, I still live in South Carolina, but I fly to D.C. for court. Luckily, we have a direct flight. It takes about an hour, hour and 10 minutes. And there's 3 of us who actually commute to the court. One is from South Carolina. She's been going for 20 years, and I was glad nobody mentioned that so we could have another one from South Carolina. Right. And then we have another one from Kentucky. Our cases are like the Supreme Court from September to May, and so we will have a docket that doesn't go along for a week, but there might be 10 sitting days, but each of us will get maybe 2 to 3 of those days. Someone told me, another fellow jurist on a different circuit said, when we were in the trial court, our cases might be a mile wide and an inch deep, but on the circuit, they're an inch wide and a mile deep, you know, in that regard. But I love the work we do. I feel like it's a history lesson because right now, because we're on that docket, we have a lot of federal agency work, including NLRB, and it's about 30% administrative law work. And then, of course, why I say history lesson, I've ruled on Holocaust survivors, international arbitrations that are going on in perhaps Africa, Guantanamo Bay, torture, terror, a lot of criminal cases, but not as much that I had, of course, at the district court level. And you just get to learn so much about what's going on in government with executive privilege, legislative privilege as well.
I should tell our attendees that Judge Childs arrived here yesterday from a meeting of the federal appellate judges in Boston, and she's not going back to South Carolina. She's going back to Washington, where there's oral argument on Monday. So I think she may be among those of us who have some homework to do while we're here. But it's certainly a demanding and busy life. The late Betty Murphy, who many of these folks know, who was chair of the NLRB under President Reagan and a longtime working management lawyer and a good one, once told me that she had been offered by President Reagan to nominate her to the DC Circuit, and she considered it and ultimately declined, thinking it would be too sedentary and that she enjoyed solving real problems with real clients. Is the life of a judge, and in particular an appellate judge, isolating in some ways?
I would say the life of a judge, particularly in federal court, is probably isolating. When I was on the trial court, I really didn't see my colleagues unless I was in the parking lot. Or if we had an actual meeting, because you have your office and your office has a hallway, and then it goes right into your assigned courtroom that no one else uses. And so you have to be very intentional. So for me, again, being part of the bar, being speakers at conferences, engaging with the lawyers and doing things like that, it has to be intentional for you to get out of that kind of cycle of that in that regard.
Not all federal circuit judges began on the district court. Are there moments in deliberations with your colleagues on the circuit court that you think you're looking at an appellate record distinctly as someone who worked as a trial judge?
I would say so, particularly when it becomes to trial or evidentiary issues. Of course, the trial judges have to make these quick, second decisions in that regard. And so you want to look at the record in context and see if there's potentially a harmless error, or if there's a guilty plea sentencing and you kind of know the colloquy that judge was supposed to go through, and just how you question people at these hearings, and not just looking at it from a very high level, but what actually happens with the trial judge and the interchange with the lawyers. And I would also say, back on your prior question, in the DC Circuit, we are in the same building as the DC trial court. And so we have a lot of high profile cases. It's not unusual for me to fly in on the morning of and then have, hearing, because we have an early morning flight, and cameras are there, just weekly, as you're going into, in that area. The other thing that I like, and I tried it last year, but it didn't work out, is that I can try cases, and I think I'm going to do that to help out the trial judges there, but just to keep me fresh and current in that regard. You
would do it in the DC District Court?
In the District Court, yes.
I'm a busy person. Your chambers your chambers where you go most of the time are in South Carolina.
That's
and the
correct.
federal courthouse you've long worked in. Tell us about how you and your clerks and your office is organized in space.
Sure. I'm very fortunate that my former colleagues allow me to have space in our courthouse down. They didn't mind having a DC Circuit judge there. And so I have a career law clerk who's there with me, and then I have some externs from the local law school. And then in DC, the other three three clerks are there with a judicial assistant, and I've got externs who work for a grade from the other area law schools. We do a lot of Zooming, but I make sure that I'm in touch with everybody every day as we're working on all the various cases.
And you see them when you're in Washington.
Of course.
And so tell us for a minute about the professional lives of your law clerks, who we all know are highly motivated and capable students to be there. What's their life like when you're in South Carolina?
Well, when I'm in South Carolina, I still participate with the local bar, the Inn of Court, and things of that nature. And then in DC, I encourage our law clerks to get out. There are some court projects where we have a literacy program that we have them go read to school, so I have them participate in that. We also have the ability to convene more with the judges because they're all in the same building. And so we started a program where each judge once a month goes into a lunchroom, and there's a brown bag lunch, so that all of the law clerks get to know all the judges in that regard. We also do cross chambers lunch where we brown bag it to another chambers and we bring our clerks, and so we get to know each other more intimately in that space as well.
You're now, I guess, in your third year on the circuit bench. Let's talk for a minute about what we often call, work-life issues. Your husband's a physician with a gastroenterology practice in South Carolina. That sounds like a busy fellow. And you have a daughter.
Yes.
And you're active in all these other things that we're going to talk about. And now you tell us you're going to want to try some cases. So talk to us about family and work-life issues, given the travel schedule and the other demands that you both have.
Well, we get our case assignments probably July for the year. And then, of course, we don't let you all know who's going to be on any particular docket until about 30 days out. I think the Fourth Circuit lets you know the morning of, And I learned by being on a panel with another Fourth Circuit person a couple of weeks ago that they do that so that you don't tailor your arguments to that judge. I'm not sure why we have a different practice in that regard. But I try to watch my daughter's schedule. She's an avid tennis player, lacrosse, and so when we know things ahead of time, we all start trading, whether we have vacation or, some conference or something that we want to go, come up. So that provides the opportunity. But I really try to be present locally among friends and family at home.
The judges on the U.S. Supreme Court, it seems to me, are frequently telling us about how well they get along and how much they agree on. I read recently that they brown bag their lunches, and one of the justices was saying that Chief Justice Roberts sometimes brings a peanut butter and jelly sandwich, and they all have lunch together. Given that you're not always in town, in Washington, how do you get to know your colleagues on the DC Circuit, and how important is it that you establish personal relationships of some kind with them?
So I mentioned the cross chambers lunch, but then it's very intentional. I'll just pop by. Like one judge from South Carolina loves Halloween, so I'll go to her chambers and look at all the paraphernalia, with respect to Halloween. And then there are other judges that we might be on a committee together, and so we have the opportunity to speak in that regard. We might attend a panel together, or we might go to a reception together. So we try to do it in that regard. Our court is very cordial. And let me give you an idea. When we, first of all, we don't talk about our cases ahead of time, with each other before we actually go to the bench. So I don't know what they're thinking necessarily until you hear the questioning in that regard. After we finish our oral argument, we will go back to conference, and then that's when we'll have a discussion. And you might have somebody who's interested in writing a dissent. And I'm literally, in this tone, they'll say, I understand what you're going to say, but I think I'm going to write separately. And then somebody else might say, well, what are you going to say? So that person who's got the majority opinion could try to continue to work to convince them, because we do all try to come together. But it's really just in that tone. And so I think it's because we take that time to spend some time with each other in that regard, and we're really working hard to get it right and to all be in agreement on any particular case that helps.
Well, to that point, I have a couple of questions that follow from that. Can judges learn from one another? And if so, what's that look like? How does that take place?
Well, we all have different backgrounds. As you mentioned, I'm a trial judge, and so I have had other colleagues defer to me or respect my opinion and want to know a little bit more about that particular type of proceeding, perhaps, in that regard. We have some other judges who are academics and maybe teach at the various law schools, and so they might be an expert in a particular area of law. We've had judges who have served in various administrations. So as you know, we get those types of cases, and so that you get kind of the inside look about what goes on in the White House or an Office of Regulatory Affairs and things of that nature. So it's a nice conversation about just generally how some of these high level cases work.
You sit on these 3 judge panels, appellate panels. How important is it for an opinion to come from a panel to be unanimous rather than 2-1 with a dissent? And why is that important, and to what lengths or what do judges try to do to achieve that?
Well, we emphasize that we're always writing for the court. Just because I'm writing the opinion, it doesn't mean I'm writing it for myself or even just the 3 judges who are on that panel. So we really push hard. So even if after conference, or in conference, we might have a term that we call dubitante, which means that I see where you're going. I haven't quite made up my mind on all these issues, so I'm going to remain dubitante until I see how you write it. And then some of the judges will come back, oh, I like the way you wrote it. I thought I was going to be writing a dissent, but now I'm going to be with you. And then even later, we will have this mechanism through the computer where we can write each other back and forth and say, okay, I went and looked at that case again, and then here's how I would proceed that. And I've been able to bring judges along, and they've been able to bring me along in that regard. So we just keep working at it to do our best to get to a per curiam opinion or majority opinion.
I see these senators asking judicial nominees about their philosophy or their approach to judging. Is there such a thing that can be explained? Do you have one? Do you associate different of your colleagues with different underlying assumptions and approaches? Can you sort that out for me?
I think it comes out more in the Supreme Court nomination process, whether you're an originalist, a living constitutionalist, or a textualist. I have not tried to peg myself in any one corner because I believe, just like some of the scholars, that each one has some fallacies. And you can try to work your way to an outcome if you try to stick in that particular line, but you can't necessarily get there through that particular philosophy. So my philosophy has always just been, I'm looking at the facts, the evidence in that particular case. I'm looking at precedent. I'm looking at text, history, legislative process during that time, and seeing where that's going to get me to the outcome.
I have a good friend who's a distinguished tax lawyer, now retired. And he says that a good tax lawyer wakes up at 3 in the morning going over in their mind the analysis in a tax opinion they gave 6 months ago, worried about it. Is there an analog for judges? Do judges do you think about past decisions or opinions?
Well, one thing I think about, and I don't know why, but it comes up in my dreams sometime about billable hours. I think that just stays ingrained in you, and I've been so long removed from that. But with respect to cases, you put so much effort in it. And I think as a trial judge on the state court, particularly when I was sentencing someone, or if I had just that part of the case, you would think about those things. But one thing I've learned to do is slow it down, which is advice from another judge. You're in charge. You don't have to rule so quickly. If you need the time to think, then just slow it down. Give yourself that opportunity to look at some more cases. Be a little more discerning about it. And of course, as a federal trial judge, when you're in charge of the cases, you have that opportunity to do that. And then of course, at this level, with drafts going back and forth, you have the time to do it as well. So I think there's probably less of a process of worrying about it so much because we have the time to actually work toward getting it right.
You're the leader of the, I don't know, are you called the president or of the whatever the association is of the federal judiciary?
That's correct.
What's that about? Why are you doing that? Why is that important to you?
Well, it's our collaborative network in which we have the opportunities to address any issues concerning for federal judges. And here's a couple of examples. I just wrote a letter on behalf of all of us with a lot of judges signing on for what they call the Judges Act. And this is for those particular districts who have been waiting for years for judgeships to get filled. And this is going to be 66 judges over the course of 10 years so that no one president appoints those judges. And we finally got close to some bipartisan appeal. There's a little more work to do, but that's an example of us coming together for something for the good of our brother and sisters. Another one was, you all may have heard of Judge Esther Salas, who unfortunately, one of the litigants came to her home, killed her son, and then injured her husband severely to where he had probably at least 15 surgeries. So in her son's name, there's the Daniel Anderall Act. We came together as the federal judiciary with the Federal Bar Association as well, and we got that act passed so that our personally identifying information would be scrubbed from the internet, because that's how that litigant found her, just looking on the internet. And then now, of course, we're working together to do so with our state colleagues as well. And we've upfitted our security systems at our home through the Marshal Service and Department of Justice and all of that. So it's those types of things that bring us together as a group because of the isolation. And we do seminars together, otherwise meet together, and any concern, with respect to a judge, we want to be there for each other.
As you're there in a position looking at the whole federal judiciary, so in that way, let me ask you this. How and in what ways is diversity among judges in terms of race, gender, background, perspectives, in what ways is that important for a court or for the whole judiciary?
Well, the word you use is perspective. And I think that when you have that broader diversity, you just have a different lens from your own lived experiences that you can bring to the table. And so we don't want to be monolithic. We want to make sure that every voice is heard at the table, because you can see the uniqueness of a lot of these issues, and that perspective helps.
Tell us about are there differences in the styles of the lawyers that appear before you now as an appellate judge in the D.C. Circuit? Tell us about what you've observed about them.
Well, there are naturally probably more routine players in the D.C. Circuit.
Repeat players, you mean?
Repeat players,
Yeah.
thank you. Yeah, that I'm getting used to in that regard. I'm still learning a lot, and I would say that comes more from the administrative law side, just because they are career people in that field. But just some really good high-level lawyering. I experienced that with the federal court as well. And it's just been such a pleasure on these highly intellectually stimulating cases to get that level of argument.
Do you still expect us to start before you by saying, "May it please the court"? Is that still going on?
If you said, "Your Honors, we're here today about such and such," I don't think I would miss the "May it please the court." So I'm not sure it's that formal, in terms of formality. And you may have noticed that the Supreme Court has shifted, where they used to come out and just start blistering everybody with questions. They're at least allowing a 2-minute or so intro. I've noticed my colleagues are waiting, for a moment, and we didn't ever, from my almost 3 years experience on there, I never saw where they were just, really going after you with questions. They do want to hear your argument, but then they may have a question on that particular issue, or they'll lead you somewhere that they want to know the answer to their concerns.
Are there things that we do in court, at the appellate court, or you could answer from the trial court, that we could do better in the way we handle ourselves in court, or in the way we write our papers?
I would say do a lot of emphasis on your writing at the trial court level, because you don't necessarily get a hearing. And so if that's the only word that the court is going to get, you have to put it all there, because those judges individually select whether they're going to grant you a hearing. I would say at the appellate level, we do have the process that goes through the staff attorney, and they'll look to see if this case can be resolved without oral argument. So, again, the emphasis is on writing as well there. But once you're in court, you have to be guided by the judge's questions. And we tend to have more of a conversation. Don't be wedded to your scripts. We're very well prepared. We know exactly what we want to ask and what we're going to focus on, because some of the issues may be resolved in our mind. So focus on what the judges are focusing on. It's very fine to have, your arguments ready, but you will be ill-equipped if you don't listen to the judge repeating, certain questions or certain themes throughout there that you want to be concerned, as well as what they're asking the other side. Because when you have the opportunity to get up, you might want to chime in on something that the judge has asked somebody else.
let's say I have a case before your court. We work like crazy, of course, on the brief, and we do 20 drafts, 30 drafts of it, and we get it as good as we can get it. Maybe we show it to some people, and maybe we change it some more, and we send it in, and then we go to dinner. And then, shortly thereafter, you call me in for oral argument. What should I be trying to do? What else is there to say? How should I think about that?
Well, don't do like the girl a young lady I mentioned earlier who says, "Why am I here?" Don't do that. So your focus is on whatever my question is, or whatever the question is of another panelist, because again, we have prepared and we are zoned in on how we're going to write the opinion. So an oral argument, yes, you've given us a beautiful brief, but I'm thinking further, how will we write the opinion? I used to decide cases that were in front of me as a trial judge based on the litigants in front of me. But now I've got to think a little further. Am I clarifying DC Circuit law? How far do I want to go? Is this saying too much? Am I going to have unintended consequences with this particular language? Things of that nature. So that's where the focus is.
I want to talk a little bit about some cases at the DC Circuit, but in doing so, well, there's some things we can talk about and some things we can't. But I'm guessing some in the room want to know about this case, Loper-Bright, which in the end of the Chevron doctrine. I don't know. Is there anything you could tell us about the way that's going to affect your life judging, or what's going to happen now?
Well, obviously you know that the case of Chevron allowed us to have deference when there was an ambiguous statute. And so the Supreme Court through Loper-Bright has indicated that particular deference is no longer available to us in that regard. But what they did not say is that you could not consider the opinion of the agency, because that's their set of expertise. What I think I'll envision is that we might be getting more amici brief in, we might be getting more expert opinions in through the underlying litigation that offers us more opportunities for other opinions. And ultimately, we have to be the ones who make the decision on what we're going to believe or not believe, just like you would at a trial court level in that regard. In talking with some colleagues right after the decision came out, one of them were on a panel and said, well, we're addressing this issue, and right now we have 3 different opinions. And so I think it will come along, and then the Supreme Court case that remanded itself back to the DC Circuit was just heard over the last couple of weeks. And just listening a little bit to that argument, there's a chance that we could come to the same opinion as particularly an agency, because it's one of the opportunities, to look at that legislation. So we really don't know until we just try a few more of these cases or hear oral argument on a few more of these cases.
You were on the DC Circuit panel that last February, on a case called United States versus Trump, that last February rejected former President Trump's claim that he's immune from prosecution over charges of election subversion. The Supreme Court reversed that decision, ruling that presidents had absolute immunity from criminal prosecution for official acts but not private acts. And we're now seeing exactly where those lines are and aren't. But I just wanted to read hugely impressive DC Circuit Court decision, of course, but I want to just read a section from it. Oh, it's a per curiam decision, opinion, did I say that? And it says, we cannot accept former president's claim that a president has unbounded authority to commit crimes that would neutralize the most fundamental check on executive power, the recognition and implementation of election results. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their vote counted. Elsewhere it says, former President Trump's alleged efforts to remain in power despite losing the 2020 election were, if proven, an unprecedented assault on the structure of our government. He injected himself into a process in which the president has no role, the counting and certifying of the Electoral College votes, thereby undermining constitutionally established procedures and the will of Congress. It's hard to read those words and not feel their importance for history as well as for the moment. Can you tell us, without telling us too much, how a panel of 3 judges goes about preparing for a case like this, conducting oral argument, and then collaborating and working on a decision of such sophistication, so much importance, and with such articulation?
Well, first, I was surprised that within a year I would have, a case of that magnitude land on me. And the way I got it was, we have a special panel every month, during that September through May, where there are cases that come up that we decide, do they need oral argument? Is there summary affirmance? Is there some preliminary injunction request? And so I was on the special panel for the month of December when the case landed. Because it was going to be expedited and I was on this panel, we decided that it was not fair to let the next panel have to hear the case, because all the work needed to be done in terms of researching, writing, looking at the underlying record right then. So once we set the hearing date early January, then we had the opportunity to comb the district court record and look at that. And again, as with any case, each chambers is just working extremely hard. I mean, I had all 4 of the law clerks on this one, for obvious reasons, because it's just a lot of work going way back to the Nixon case and, bringing it forward and perhaps looking into that file as well, and then getting ready for the oral argument. But what we knew that we were going to do was make sure that we treated it like any other case, like any other litigant, started on time. The part that I was quite surprised with and hadn't thought about, because I'm not in DC, I forgot the backdrop that there were so many January 6 cases that were already tried at the DC circuit. So in that regard, there was a lot of security around the courthouse and within the courthouse, just because you just don't know what the temperature would be. And so when we walked out, the president was there, and as I stand in oral argument, I always just kind of span the entire room, and then we call the case, we then sit down. I was very proud of my sister colleagues because we were very professional, we did not let it get political, we asked very specific questions on all the issues that we needed to deal with, in that particular hearing. Then we go back to conference and do like we do regardless. And it was very important to us to work hard for the institution to attempt to get to a per curiam opinion. And then that way nobody's just kind of out front on it. So we each took a portion. I won't say who wrote what, but of course we vetted back and forth. And then what takes a little while is that with any DC Circuit opinion, we always email our colleagues or post it and say, this opinion is intending to drop on a certain date. And that's for every case. So you can comment on a case that you weren't involved in, or sometimes we need that because we didn't know you have the same issue in your case and we might affect you. And so you just have those opportunities. So we had to just go through the waiting period of all of that, the back and forth. And then I knew exactly, when it was going to drop. But then we did the same thing where you just regularly dealing with all of this. And of course, there's so much at stake in it that you're just, ultra vetting it, if you will. And then we got to our result.
Well, I have more, but we're short on time. I don't see a mic out there, but surely I invite any of you to ask a question on anything you would like. Sir, stand up and ask it so everyone can hear it.
Everyone can hear. I would like to hear your views on nationwide injunctions.
Ah.
It seems political when a court in Texas enjoins a policy of a Democratic president, or when a court in the district court in the Northern District of California enjoins nationwide the policy of a Republican president. Makes it seem political. I worked clerk for Judge Abner Mitva, who used to say the courts have been in the thicket of politics since Marbury versus Madison. But this seems particularly extreme. Are your colleagues on the circuit courts giving any consideration how to address the problem of nationwide injunctions?
I would have to say that that's going to come before me and has. So I wouldn't be able to answer that particularly, but that is the discussion. I will say, being in other conferences and other places, that question comes up a lot. So you'll just have to wait for our writing.
Someone in the gentleman in the fourth row, and then we'll get this other gentleman. You, sir.
Over the years, I guess I've been more and more concerned about the judicial system really not being available to those who are small entities. They can't afford the lawyers, they can't afford the delays in the process. I personally think the Equal Access to Justice Act should be strengthened as one solution to that, at least between government and small entities. But from your bench, it seems that the rule of law is ephemeral to a lot of people who just can't afford to use the system. Do you think that's a legitimate concern, and is there anything we can do about it?
I do think that's a legitimate concern, and unfortunately, lawyers are probably the only profession that is required to work for free. And so it's really up to the lawyers to offer that volunteer service. But the way I look at it is, because you talked about the jury trial vanishing, because you talked about less opportunities to actually be in court, we need to probably groom and mentor the younger lawyers to help them with these cases and maybe serve as a second chair with them on certain cases. I know that whenever I had a pro se case, it's hard to be in court with a pro se person. Right. So we had, at least at our district, had a volunteer list, and I would call a lawyer and I would get the case managed as best as I could for it to not be more than a day, so that you didn't have a whole lot of input, you wouldn't be there for a week, and then call a few lawyers and say, can you run your conflicts? Would you like the opportunity to come and try this case? Because they just aren't getting that experience. So I think that's a way to do it through the bar, is to help the young lawyers get that experience.
Sir, maybe I should stand up, and maybe I should be inviting the questioners to tell us who they are.
Hi, my name is Claudio Martinez Esteban. I'm originally from Mexico, and it's a pleasure to be here. Thank you for everything you said. Your journey has been amazing. I want to be like you when I grow up.
Thank you.
My question to you is the following. So in Mexico, we recently had a new, they changed the whole the whole judicial law, and now all the judges have to go through a democratic process. You used to have a judicial career in order to become a judge or in order to become a Supreme Court justice. I have my personal opinion, because now I don't have to do that to become a minister of the Supreme Court. But I want to ask you, as a judge, with all your journey, what do you think about this type of norm that now judges would be elected by everybody, and it's going to become like a little more of a politicized issue?
Well, on the state side, you have that already occurring in the United States. I think some of the problems occur when you have to declare being connected to one party or another, because then people tend to represent their views, and we're supposed to be neutral, but you're sitting out there raising money, giving a partisan view and telling people how you're going to rule on, very high-level matters like capital punishment or, anything else. And so I think that's where some of the criticism comes in the process.
Thank you for your views.
Other question? Sir.
Patrick Flynn from Houston. I just wanted you to kind of elucidate a little bit more on what the D.C. Circuit judges do to prepare for oral argument. You told us about the conference.
Oh, sure.
After,
Sure.
And
Oh, yes.
talk about how well prepared everybody is at the time it starts. Can you?
Oh, certainly. I mean, I'm up in my room before I came here, and I'll do some more before the dinner tonight. But we get our stack of briefs. They're delivered to chambers, and then you assign a clerk to assist you on that particular set of briefs. We're reading the entire record, and then I will have my law clerks do what I call conference paragraphs, or like a skinny, that helps us get to an answer, what their recommendation may be to me. But I'm reading along, I'm sending them questions, we're having discussions along the way. And then I also have my law clerks, because they're in appellate jurisdiction and they want to potentially be an appellate lawyer, they actually present the arguments to the entire chambers. And so we're also giving them questions so that we can make sure that we hear the full information on both sides, and make sure that we're not, just siloed and guided by one side. Then they will do anything else that I need in terms of a bench memo. Sometimes if it's very complicated, I might ask them for a decision tree, because you're working through that. Or I might ask them for a chart of cases on how the DC Circuit has ruled on particular issues, so that I know that going into a panel, I already know what that judge has done before, me. And so there's various ways that we all get prepared in that regard, and then we walk into the room. So it's an extensive process.
One follow-up, do the fellow panelists communicate with each other?
We don't. The only time, I'm only meeting with my clerks. The only time we communicate with each other is if something got set for argument. There's a rule 34J that we can say we can take it off argument because we believe that we can decide that issue without the need for argument. That it may have gotten simpler, things of that nature.
Other question? Yes.
Hi, I'm Mary Jason. Do you have any particular do's and don'ts about effective briefing or homework that will be for those who appear before you?
Certainly. In terms of the briefing, obviously it's brief, so we want you to be concise. And I just want you to think about this perspective. I read 500 to 1,000 pages a week.
Right.
Okay, so you need to make sure that your words are getting lifted off the pages and you're just not being verbose. Like
Right.
just because you have the 35 or the 80 pages or whatever we said we give you on increase, that you don't have to use all of it. You want us to focus. You want us to know the story, in terms of what lifts off the page. And that's why I asked my law clerks, I said, think more, write less. I want a skinny of what you think are the issues and what your recommendation will be to me, and then a few bullet points on how you got there. Then you can go back and do a bench memo for anything else I need, because I don't need you to give me 30 to 50 more pages to read when you, synthesize all of that. So be, very crisp. Your table of contents should be a really good guide to what the argument's about, because I can open the brief and then immediately say, okay, this is where they're taking me, in that regard. And then I can't emphasize enough, do not avoid the questions that are coming to you, because that's what's going to go over into the conference at the time. That judge wants to be clear on certain issues. And I will say that the way I have understood it from my panelists, we respect you all. I'm a generalist. You're a specialist. You know your area of law. And so you got to understand you've been living with that case for 2-3 years. So there may be something that you think should be very basic to us, but that's your language. And so listen to that as well if we're asking you to, just break down, certain concepts and how you get there as well.
John Sands. And then after that, we'll take the one from the back. Go ahead.
Like Claudio, I'd like to be like you when I grow up.
Thank you.
I have to applaud you for the fact that having become a judge at a very high level, you are a human being throughout.
Thank you.
And that's wonderful.
Thank you. Thank you so much.
I think that was a leading question, but yes.
I'm Gloria Portella from Houston, Texas. And like this gentleman just said, I find your life story incredibly compelling. But today, a week after last week, I find your optimism and your brio even more impressive. So if you can answer this question without breaching any judicial ethics, as an optimist, what can you tell us that makes us optimistic about the judiciary and about our country?
And thank you for the question. We all have a role to play in our democracy. From voting, to running for office, to participating in bar organizations and leadership, guiding on civics education, our children, college kids, those who are in the workforce, they're all looking on to us. So we all need to be, respectful as judges, and even, toward my fellow judges, be civil to you all as litigants. You all be civil to each other, as you're practicing law. In my opinions, I try to make sure that I'm not engaging in any kind of judicial activism, that I'm dealing with the case or controversy that's in front of me, and that I'm writing with clarity so that anyone can understand that this is the decision by which you'll be guided, and serving as that check on ourselves and on each other.
I think that's a good place to, one more.
I'm
Adele Rapport.
I'm a government lawyer and the meeting past chair of the Government Public Lawyers Association. So I'm speaking in that capacity, and we actually have a resolution on this issue. But you touched on the issue of the security of the staff and their private information about where they live and their families. And I was just wondering if you could talk, I mean, this is an issue for all judges at all levels and their staffs and clerks. If you could just speak about some of the, reasons why that should be sort of a national scrubbing of information about staff so that, people are more secure in taking these positions, including.
Oh, absolutely. And I do think that it should take its next levels. Obviously, when something happens to a judge and you're at this level in the judiciary, unfortunately, we respond to tragedy. We respond to bad things happening when those things should have occurred well before the incidents in that regard. We're very careful about staff too in their activities outside of work too, because you don't need to draw yourself into it. I'm very careful about my law clerks with respect to how they're on the internet, beyond profession. Don't draw yourself to me. I don't like them to tell you what I had for lunch last week. Just be very careful. Don't talk about cases. Don't necessarily be working around anybody in your atmosphere, because we see the leaks, just those types of things. And so we just have to be very conscientious about everything that we do and make ourselves a much more sound and responsive organization where we respect the integrity of the institution.
I think we're out of time. Thanks
Thank
to you all,
all.
and thanks to Judge Sachs.
Thank you.